Hello, my name is Lee Akazaki. Today we're here to talk about what clients should be thinking about when they go to see a lawyer about separation agreements. And I'm here today with Andrew Sudano, an expert in family law. Andrew, let's jump right into it. What are the important considerations people should have when drafting separation agreements?
Well, I think people should know going into even before considering whether or not they want a separation agreement, is do they have the ability to compromise and work together with the other party? Because a separation agreement is essentially that, a compromise, figuring out how parties can determine what's best for them and their families moving forward. And if the parties don't have any ability to communicate, or there's a high degree of conflict, then right at the outset you might think that a separation agreement isn't for them. But taking a step back from the high conflict realm, separation agreements can be very useful and very cost saving for a lot of families. And it really allows parties to get into the very detailed, or no details possible, on how they want to divide their assets, or arrange for child care, or pay support. So it allows for a lot of flexibility for parties to ultimately create some sort of structure to determine what's best for them and their families moving forward.
Well, let's talk about that for a minute. What are the specific clauses that you would be interested in if you're a family with children and wanting to develop a parenting schedule?
Well, some considerations would be division of, other than the obvious parenting schedule, which is where the child is going to reside primarily, and like the normal weekend, week off, things like that nature, as agreed upon between the parties. More specialized or detailed scenarios would be division of holidays, such as who's going to get March break this year, who's going to get the Christmas holidays, PA days, other special occasions like birthdays, or parents' birthdays, or Mother's Day, Father's Day, things like that, which can certainly reduce the amount of conflict between the parties, because it's set out in the agreement as to who's going to be doing what. But other clauses, like taking advantages of the schedules you can attach to a separation agreement, such as the travel consent, which makes it easier for the parties to know, well, what document do I need to be able to travel with the children, and setting out the structure as to who's going to be doing what when one child decides to travel with a child. And even other general travel clauses, such as giving the other person notice, like 2 months notice beforehand, along with a copy of the travel itinerary and contact information, also goes a long way for the parties to know what's going to be happening when, and of course make other arrangements for make-up access for the parent, for the non-traveling parent.
What about special cases? Like, a lot of families have children with special needs, or they have very demanding extracurricular activities. Can you tell us a little bit about how you deal with that type of situation, or those situations, in a separation agreement?
Well, I would recommend to my clients that they make any and all extraordinary expenses, or expenses resulting from a child's special needs, or even those arising from like dental, medical, orthodontics would be a significant one, that it would be as agreed upon between the parties. And the reason for this is that, for instance, if we had a child and you wanted to enroll that child in hockey, and our child played competitive hockey, and it would cost to the tune of something like $8,000 a year, and I didn't want to pay, well, that might be a bone of contention between us. So you want to set out in the agreement as to who's going to be doing what, and how the parties are going to arrive at calculating these, or dividing these expenses, to avoid the escalation of conflict in the future, and one party essentially racking up the bills for the other.
Well, it's all about the kids, but kids grow up, children grow up. When children become adults, how do you deal with the termination of the provisions in a separation agreement?
In most separation agreements, you have a set of clauses which should say that upon the earliest of the following events taking place, child support would be terminated for any of the children. And some of these events would be when a child reaches a certain age, like either 18, 23, 25, when a child obtains their first undergraduate degree, when the child marries, when a child becomes self-sufficient, when a child obtains full-time employment. These are some of the standard clauses you would have that trigger. But I would highly recommend that a person speak with a lawyer about how those triggering clauses would play out, to go through all the different scenarios for that specific family, and of course that specific child, as you mentioned earlier. Some children might have special needs, and there could be no termination date for that specific child, as the child could still technically under the Divorce Act be eligible to receive support for the remainder of their life, as they would be unable to withdraw from their parents' care.
Okay, one more last question. When families separate, when couples separate, they divide their assets. Can you tell us a couple of things that people, in your experience, you find do wrong when they're coming up with a separation agreement?
Well, I would, one often thing I see is that the parties, when completing the financial statements themselves, they would generally need to speak with a lawyer to really understand how to complete it properly, to make sure that they divide their assets correctly. And I'll give you an example. When completing the financial statement and the division of property statements, called Form 13B NFP on division net family property, the form asks for the date of the marriage, and that's straightforward, and the valuation date. The valuation date is also the separation date, but there might be a dispute between the parties as to what the separation date is. And it's important for the client to speak with a lawyer to determine what date that is, because not only does that valuation date dictate all of the calculations and all of the agreements, but it could also depend on, or it could also factor into how the assets are going to be divided, if they are already divided. And I'll give you an example. If two people separate in February, but then ultimately decide to begin to divide up their assets in March, and then move out and live separate and apart in April, there could be an argument that, well, April should be the separation date because we no longer live together. When in fact, if the parties agreed to separate in February and have already begun dividing their assets, well, then the date of valuation should be in February. So it's very important for people to speak with a lawyer on that specific issue. Another one would be the importance of full and frank financial disclosure, not only because the absence of that could result in the entire separation agreement being set aside because one party had no idea what the other person's true financial picture was, but when a client comes to see me and they say in their agreement, Andrew, I have no idea as to how these numbers were calculated, your guess is as good as mine, I tell the person that my advice to you would be is to absolutely do not sign this agreement, because you have no idea what bargain you're signing.
Well, I think we could go on and on about these various subjects, but I think that you've taken some of the mystery out of separation agreements for us. So thank you, Andrew, for discussing these issues with us, and thank you for tuning in.